Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We also, of course, welcome those who join us as they do on all occasions on our heritage.org website. For those in-house, we appreciate you checking that cell phones have been muted as a courtesy to our speakers. And of course, for those watching online, you're welcome to send questions or comments to us at any time via email at speaker@heritage.org. We will, of course, post the program following today's presentation on our website for everyone's future reference as well. Introducing our program and a special feature at the beginning is Ryan Olson, who serves as a research associate in economic freedom in our Center for Trade and Economics. He researches and writes on a range of issues, including international economics and development, economic freedom, and trade. He also helps write, edit, and promote Heritage's premier annual index, our Index of Economic Freedom. He began his career in service in a rather unique location as an English teacher in volunteer capacity in the country of Georgia. He then came to Washington, D.C. as a staff assistant for then Congressman Cory Gardner of Colorado before joining us. He has a master's degree in international commerce and policy from George Mason, and he received a graduate certificate in international NGO management, as well as a bachelor's degree in political science from James Madison University. Please join me in welcoming Ryan Olson. Ryan?
Thank you, John. Thanks everybody coming out today, and welcome to the Heritage Foundation. So today we mark the 10th anniversary of the Kelo versus City of New London case. As this is a case that has had an effect on both the legal world and also the residents of New London and those who have been affected by its outcome in the 10 years since it was decided. In this case, Ms. Kelo and her fellow plaintiffs lost not only their homes, but also a battle to limit the government's ability to seize private property and transfer it to other private parties. This story and the constitutional implications would be tragic enough if it wasn't for the fact that the economic development promised to the Fort Trumbull neighborhood never came to fruition. Today, as you'll see from the video that we're going to show shortly, the lot that Ms. Kelo and her co-plaintiffs' home sat on remains empty. Meanwhile, legal scholars and state lawmakers have been forced to deal with an expanded definition of the takings powers, and these are powers that threaten, or these are implications that threaten the most politically vulnerable in our societies. So today is not really a day for celebration, but a day for reflection on property rights in the United States, especially in the past 10 years since the Kelo decision. And we have a very special program for you to mark this occasion. We're going to start out first with a short video produced by Melissa Quinn and Alex Anderson of the Daily Signal, our in-house news outlet here at the Heritage Foundation. And then after that's finished, we'll move on to our panel, and I'll do introductions then.
This is what the City of New London wanted. This is what they took our homes for, this vast amount of land. You know, this is what the U.S. Supreme Court said, that the City of New London was justified in taking our homes, okay? An empty field. You know, as far as I'm concerned, it's an empty dream.
In the late 1990s, residents of New London's Fort Trumbull neighborhood found out their homes were being taken by the city. The city wanted to transfer the property from the residents to a private development company, and they fought back. The case went before the Supreme Court, which ruled 5-4 in favor of the city.
When I first started this battle, it was about me and my little pink house, but it grew into something much bigger than that.
Kelo and her neighbors' properties were taken through eminent domain.
Eminent domain is the power of government to take someone's property away from them. The Constitution of the U.S. and of every state imposes two limits. It has to be for public use, and just compensation must be paid.
We actually really couldn't believe that, that they could take somebody's home away from them to give it to a developer to develop for not a public purpose.
Michael Cristofaro grew up in the Fort Trumbull neighborhood in his parents' home. When they learned the city was trying to take their home, the Cristofaros joined in the fight against the City of New London.
Personally, I had a hard time coming here for 7 years. Right at that third telephone pole with the gray transformer sitting up on top was where the entrance to my family's homestead.
There was 97 acres, I believe. There were, I think, 78 homes. they were all torn down for the redevelopment project that never happened.
Here we are, 2015, 15, 16 years later, no development, nothing.
Eminent domain is used against the people who the government thinks can't fight back. People need to organize in opposition to eminent domain when it occurs.
Now 10 years after the Supreme Court's ruling, the City of New London is still trying to figure out what to do with the land.
My name is Darrell Justin Finizio. I'm the mayor of the City of New London, and I became mayor in 2011. We have not committed the worst sin of eminent domain in the Kelo case until we transfer that property to private development, and that has not happened yet. And if we can find another way forward where we can use traditional public use on those lands, that would certainly be the way that I would want to go and the way I'll advocate for.
More states need to pass stronger laws. The states that haven't passed anything definitely need to pass strong laws. But I do think eventually Kelo will be overturned. The court will have to do more than that to get back to the original meaning of public use.
Many of the old Fort Trumbull residents left New London after their homes were demolished, and the memories of their fight still sting.
I have not been back to the Fort Trumbull neighborhood since I left it. They took our homes by eminent domain. I don't think, I think there's several of us that haven't been back. I mean, it's just a hurtful spot.
Susette's house was, right here in the corner. And actually the stairs used to come right up here and they used to go up. It was a cute house and she took such wonderful care of it.
Your home is your sanctuary and it should be protected by the government so you can have your home and live there and have your life, your dreams, your memories.
That really puts it into perspective and kind of help us cue off our discussion. So let me just start out by introducing our panelists, moving straight down to my left. First, we have today Paul Larkin. Paul is a senior legal research fellow in the Edwin Meese III Center for Legal and Judicial Studies here at Heritage. Paul directs the Heritage Foundation's project to counter abuse of criminal law, particularly at the federal level. Before joining Heritage, Paul was at the Justice Department as an assistant to the Solicitor General and as an attorney in the Criminal Division's section on organized crime and racketeering. He argued 27 cases before the Supreme Court. Paul also served as the counsel to the Senate Judiciary Committee and the head of the crime unit for Senator Orrin Hatch, then the panel's chairman. He also worked at the EPA and in the private sector, including time as general counsel for Verizon Communications. In 1994, Paul received the Secretary of Defense's Medal for Meritorious Civilian Service for representing the military before the Supreme Court. Paul received his law degree in 1980 from Stanford Law School, where he was published member of the Stanford Law Review. He also has a master's in public policy from George Washington University and a bachelor's of arts degree in philosophy from Washington Lee University of Lexington, Virginia. And unfortunately, Paul is also a lifelong New York Giants fan, to my dismay. Next to Paul is Dana Berliner. Dana serves as the litigation director at the Institute of Justice, where she worked as a lawyer since 1994. She litigates property rights, economic liberty, and other constitutional cases in both federal and state courts. Along with co-counsel Scott Bullock, Dana represented the homeowners in Kelo versus New London. She also defended property owners for eminent domain takings in California and Ohio, including the famous Norwood versus Horney decision before the Ohio Supreme Court, which was a resounding rebuke of the Kelo decision. Dana is the author of 2 books, Opening the Floodgates, Eminent Domain Abuse in the Post-Kelo World, and she's also authored Public Power, Private Gain, a 5-year state-by-state report examining the abuse of eminent domain, the first nationwide study of the abuse of eminent domain released since 2000, and it was released in 2003. Dana received her law and undergraduate degrees from Yale University, where she was a member of the Yale Law Journal and represented clients through their legal services program. And last but not least, to Dana's left is Darren Basque. Darren is a research fellow in agriculture policy here at Heritage in the Thomas A. Rowe Institute. Darren studies and writes about agriculture subsidies, property rights, environmental policy, and food labeling. Previously, Darren was policy counsel for the U.S. Chamber of Commerce, where he focused on regulatory reform as well as food and agriculture policy. Before that, Darren worked in Raleigh, North Carolina-based John Locke Foundation, one of the largest state-based free market think tanks. As a director of legal and regulatory policy there, he concentrated on property rights and environmental policy. Darren received his bachelor and master's degrees from George Washington University. A licensed attorney, holds a degree from University of Miami, and a Master of Laws degree from American. So start with Paul.
Thank you very much, Ryan. I appreciate it. As you saw in the video, and as Ryan mentioned, while the discussion today will be on property rights, it's a mistake to consider property rights as limited to realty or personalty, because only people can own property. And what you saw in the video was an example of how the government can damage people through its regulation of property. Now, there are times this may have to happen, but this was a case where it didn't. And this was a case where the courts should have intervened to protect not only the individuals who are property owners, but also who, in fact, were the type of politically powerless individuals that the courts normally seek to intervene to protect from the legislative process. As my colleague Dana will explain to you, perhaps, we have a situation here where the court ought to have stepped in to prevent this from happening, but didn't. Now, conservatives generally will be very critical of the courts if the courts wind up creating constitutional rights that find no home in the text of the Constitution. But as you can see here, this is almost a polar opposite. If you look towards the end in what is red, you will see the phrase, "Nor shall private property be taken for public use without just compensation." In effect, what the Supreme Court has done over time is not to create a constitutional right that has no home in the text, but to erase a constitutional right that is expressly referred to there. So how does this come about? Well, what does this phrase mean? Does it mean, for example, that the only time compensation must be paid is when there is a taking for public use? Now, linguistically, that may be possible, but it makes utterly no policy sense. If you own a home, if you own land, you suffer the same harm whether the recipient of the taking is the government or one of its agencies or some other private party. Requiring the compensation be paid only when the government takes the property for itself rather than a private party also encourages the sort of manipulation of the process that you can imagine legislatures might readily want to engage in. All they have to do is take it for a private person, lease it back from that person for 99 years, and then at the end of the 99-year lease, buy it from them. So it can't really be said that there is a sensible way of reading this clause as limiting the compensation to only takings that are done for the purpose of the government. So the other best alternative of this is, in fact, what it does is it assumes that the only times takings can be done is when it is for a public use. And buttressing that interpretation of the text of the Constitution is the fact that the compensation formula also assumes that takings will only be for a public use. Keep in mind that the compensation is paid out on the fair market value of whatever property is taken. If you take it for either use by the public or use by the public representative, which is the government, or in some instances by a regulated entity that is essentially performing a public service under government supervision, every member of the public, including the person, unfortunately, whose land is taken, benefits to some degree from it. So if all you're doing is compensating that person for the fair market value of the property, you are to some extent making up for the fact that there are certain personal subjective values that people put on property that the government doesn't have to pay you for. It may be that this home was in your family since the Civil War. It may be that you were born in this home. It may be a million and one other things that you attach to this home give it tremendous personal value. Well, the government doesn't have to pay you for that. But if the government is taking it only for so-called public use, then there is some effort to try to compensate you in that regard, because you, like every member of the public, are going to be benefiting from this. On the other hand, if you take it from Ms. Kelo and you give it to a drug company, it's the drug company, by and large, that's going to be doing the benefiting, not Ms. Kelo. Now, how did we come about with this situation? Is it that the common law against which the Fifth Amendment was adopted didn't provide a great deal of protection for private property, so the Supreme Court, the federal courts, and the state courts don't have to do so either? Well, that's absolutely not the case. If you read many of the great common law writers, such as Blackstone, if you read many of the great economists of the time, such as John Locke, if you read the works of many of the great framers, such as John Adams, and James Madison, you will find that they put a tremendous value on private property ownership. In part, that was because it was the only way to become independent at the time. Property gave you an independence from the government and from everyone else. So anyone who owned property was entitled to a tremendous amount of protection against the government taking it away, because taking away that property essentially took away a large part of your liberty. So it is not the case that the courts, by giving very little protection to property rights, are just honoring the intent of the people that wrote the common law or wrote the Constitution itself. In fact, they are dishonoring the values that those people had in place. Well, is it perhaps because there are other provisions in the Constitution that show property isn't worth very much? That also is wrong. Take a look, for example, at the Commerce Clause. It limited Congress to interstate commerce, which essentially was because they didn't think that Congress had any business or any authority to deal in the question of property rights. And they limited Congress to interstate commerce as a way of protecting the property rights that people had. Look at the Contract Clause. They didn't apply that to Congress because they didn't think Congress could be meddling in contracts, but they did apply it to the states, in part because they didn't want the states to repudiate their debts incurred during the Revolutionary War, but also because they wanted to be able to protect the contracts that people entered into to buy and sell property. And finally, if you take a look at the Territory Clause, you'll see it says that Congress can take property that they can purchase from the states, which tend to indicate that maybe that was the way the framers thought the federal government could go about acquiring property, that the states would buy it for them and sell it to the federal government rather than the federal government doing it on their own. Now, of course, they weren't worried about the states too much in this regard, taking property in impermissible circumstances. After all, the states were entitled to set the qualifications to vote or hold state office. Virtually every state had some type of property qualification. And the vast, vast majority of people in the colonies at the time owned property. It was one of the most important factors distinguishing Americans from Englishmen. Englishmen largely worked on the property of somebody else. Americans owned their own property. And so the protections that you had to some extent and the value that property had at that time was somewhat like the water the fish swim through. They're not really aware of it, but it does give life to whatever they're trying to do. Despite all of that, the Supreme Court over the course of its tenure has repudiated what the framers essentially tried to do here. They did this to some extent in part because they probably didn't realize what they were doing early on. The very first case interpreting the Public Use Clause didn't arise during the colonial period. It didn't arise in the first quintile or half of the 19th century. That was an unfortunate development because what it meant was when the Supreme Court finally started deciding these cases, there was no one on the court who was a contemporary of the framers. No one who was on the court who knew at the time the value that our framers and the public as a whole placed on private property. In fact, because the very first public use case wasn't decided till the Gilded Era, what you had was a situation where the economy was changing markedly from a primary rural and agricultural-based economy to largely urban and manufacturing-based economy. Property, therefore, did not necessarily, at least in real property, have the same importance. It didn't convey the same value to people at the time, and since justices are people, they probably didn't come to these sorts of cases with the notion that this was something that should be protected, as the Due Process Clause, for example, says, on a par with life and liberty. So what the Supreme Court did, in essence, was make a mistake in trying to decide not only how to interpret the text of the Constitution, but how law had been developing up to this point. They wound up in a case called Berman versus Parker in the mid of the 20th century, saying that any action that the government took that was within its so-called police power was an action that satisfied the Public Use Clause, forgetting that the police power and the entire Takings Clause were designed not to be overlapping. If something was within the police power, then it was not a taking, and therefore didn't have to satisfy the Public Use Clause. But if it was an impermissible exercise of the police power, if it went beyond what the Constitution and the framers assumed the police power would permit the government to do, then you had to satisfy these requirements, and not everything would satisfy the public use requirement. Berman, however, was only the first of the cases, and you could perhaps excuse the Supreme Court because what they were dealing with was a problem of so-called blight, which I think Darren will talk more about. It was urban renewal, and the Supreme Court perhaps was thinking that the people who were living in these areas, although oftentimes predominantly African American and therefore at the time in the early 1950s politically powerless, were nonetheless going to benefit from this activity. Ask them if they thought they were benefiting when someone took their home, but that's another question. But in Hawaii Housing Authority versus Midkiff, we then turned Berman on its head. no longer were what we were doing was trying to remedy a blighted area. They were now taking highly desirable property and giving it to other people because it was in fact desirable. And it was therefore the exact opposite of what we had in the Berman case, and therefore gave tremendous boost to developers in this regard. And the shoe finally fell in Kelo, where what they said was you can take property from A and give it to B as long as the state can make a non-red-faced case that is going to benefit the public as a whole. What we have, therefore, is the unfortunate situation today that the public use clause serves largely the same function that a civil servant does in a highway toll booth. It just makes sure that the fee is paid, the just compensation is paid before everyone can move on. And that litigation over these sorts of claims largely is done in a pretextual manner. Lawyers will argue that there is a legitimate public use or public need, and the courts will pretend to actually believe what the lawyers are saying. The result is, perhaps legislation is necessary, or certainly a revisitation of this issue is necessary by the Supreme Court, because property owners, people who were put on a pedestal at the time the Constitution was adopted, are now essentially under it, because they are now in the position where whatever the government essentially wants to do with their property, as long as it's paid, can be done. As long as somebody can claim to make a better use of your property and give you the so-called fair market value for it, you can have that property taken from you, even if, as Mrs. Kelo found out, it's your own home. Thank you.
Thank you, Paul. Dana?
So I completely agree with Paul's analysis that there is little to nothing left at this point of federal constitutional protection against takings for private use. And this is, of course, a huge problem because it means we don't have a federal floor anymore. We don't have a federal constitutional protection. Now, I do want to talk about the developments that have occurred since Kelo in the States, which is not by no means complete, but still a more hopeful picture than you might otherwise think. So nobody's won in federal court about a takings case since Kelo, or about a public use case. There is nothing to be done under federal law about it anymore. However, there was, after the decision, a huge backlash. And I'm sure all of you heard something about it the next day. I myself was walking down the street and heard people talking about it every few feet. People were really outraged by the case, and the poll numbers ran somewhere between 80 and 90% against, shortly after the decision was decided, and years later. People, the majority of people, do not like the use of eminent domain for private parties. They're not real keen on eminent domain in general, but they particularly don't like it being used for private projects. And the result of that was the largest state political backlash, I think, that's been seen on any issue. In the wake of the decision, 44 states changed their laws. There were 40 who changed that by statute, 41 if you count New Jersey, which I don't. And then another 11 that changed their state constitutions. There were 30 states that changed their definition of public use. There were 25, I can't remember all these numbers, there are 25 states that changed their definitions of blight, which I know is something that Darren will talk more about, but it involves the justifications used for taking the property. The point being, there was a massive legislative change in response, and state high courts, state Supreme Courts also participated in this. In 6 of the states that didn't change their laws, 3 of those high courts actually made it harder to condemn for private use. And then another 7 courts did other good decisions, some of which toughened up some kind of weak statutory reforms. So there actually was a substantial change for the better in the use of eminent domain for private development since Kelo, because although if anyone took it to federal court, they would win, you couldn't do it anymore in most states. Now, there's a big qualifier there. It's only most. And that's, of course, no way to deal with a federal constitutional right. It says for public use in the U.S. Constitution, and that should protect everyone. It does not. So, for example, in New York, which didn't pass a law, has a terrible high court, you can take property for anything, absolutely anything. They have taken property for, like, a CVS for a Walgreens. They've taken property for private development around a Nets stadium that wasn't going to be anything that they promised, and all the evidence said that. They took it for Columbia University. They took it for a private industrial park. You can take property for anything at all in New York, and the courts will not stop it. Colorado is also very bad, surprisingly, because up until Kelo, Colorado wasn't that bad, and suddenly it's really had an explosion of the use of eminent domain for shopping malls. And there's a couple every year now, which is very strange, but in part that's due to their bad definition of blight, in part due to some procedural things they do there. But the point being, we have a strange situation now where you have something that ought to be a basic right, and it's completely variable. If you're in New York and a homeowner, you're completely out of luck. If you're in New Jersey, it's not so clear. The state court is kind of okay. You should go to court and litigate about it for 7 years. And then if you're in New Hampshire, you're totally protected. So this is not a good way of dealing with constitutional rights. It's not the way we deal with any other kind of constitutional right, and it's not what ought to be happening here. But it is still, for people in most states, a better picture than what it was before the Kelo decision. It is also true for the people in New London. It was a total disaster. I mean, you saw what happened there. Pfizer got a 10-year tax break. That was part of the whole package. Come to New London, we'll give you a 10-year tax break. We'll redo all of the land surrounding it and build a hotel and condos, and it'll be so pretty. And then as soon as the 10 years was up, Pfizer moved. The tax breaks were over. They didn't have any intention of staying. They left. So they're gone. Not only was nothing ever built on the condemned land, they never even proposed that they build anything. So there's been a series of like 5 different developers. Each one comes in, and they have some proposal to use an existing building that was not taken by eminent domain, but no one ever thinks you can build anything on the land taken because there was never a market for it. Every homeowner moved out of New London. Susette still won't even go back. But nobody stayed in the city after that. And you can understand why. They were forced out, and what was a lovely, cute New England whaling neighborhood is now a field of weeds, cats, and storm debris, which is where they place it when there's a big storm. So for New London, it was a disaster. I disagree with the mayor that if only they just do something completely useless with it or leave it as a field, they haven't committed the ultimate sin. I mean, the ultimate sin's kind of over. They took it for private development. Now they can't even do that. And that's, to be honest, pretty common. We keep lists of all of the failed eminent domain projects, and they usually do fail, or they don't live up to what their promises are, because if there was a market for it, someone would have done it privately. These are projects that someone in a city government thinks, wouldn't it be nice if there were something big and beautiful there, which they have no reason to believe will ever be built, and then they lay waste to the neighborhoods they do have in order to further this dream that will not occur. So let me talk then just for a second about what can happen now. I know Darren's going to talk a lot about federal legislation, which I won't talk about. But we still need further state political reform and state court decisions that restrict the use of eminent domain. I'm not saying we shouldn't have federal protection. We should. The U.S. Supreme Court should take this again. It should overrule Kelo, and I actually think they will do that, but not now. They've nixed the last 5 cert petitions. They're not touching this for 10 years, probably. So they should overrule it, but states have constitutions too, and states should be protecting against this kind of abuse. So that, I think, for right now, is going to be the best statewide political solution. And the other solution, actually, is grassroots activism, which has been remarkably successful. We work with activists throughout the country fighting the use of eminent domain. And since Kelo, working with activists, we've saved 16,000 homes and businesses that were threatened with eminent domain for private development. And once their communities rose up against it, they actually backed down. All of this would be unnecessary if we had actual constitutional protection that we should, but while we don't, there is still a lot that can be done to prevent eminent domain abuse.
Thanks, Dana. Darren?
I'm going to go crazy and stand up here. My game plan is to touch briefly about Kelo, because it's been covered so well, but then really focus on what should Congress take action, and spoiler alert is yes. And what should that action be? I'll talk to you about that. It's important to recognize that no property is safe after the Kelo decision. You could be hanging out in your living room one day and get a knock on the door, and now the city wants to turn your house into an Orange Julius. That's possible. Obviously, some states are going to be different, but just based on Kelo itself, property is at risk. The idea is that the government's always going to think of some higher, more beneficial use for your property. And so really that public use is just basically crossed out of the Fifth Amendment. The people who are going to get hurt the most are going to be usually low-income individuals. If you're a city, you're going to take property that's lower in value. It's going to cost you less and then you can have more upside potential. And also those people that don't have as many resources, they're not going to put up the fight that somebody that does have resources can put up. So it's usually going to be kind of a reverse Robin Hood effect, taking property from the poor and giving it to the rich. Look, if you're an inept city government, this is one of the best things to happen to you in years. Look, cities love annexing property outside of their boundaries and bringing it in for more tax revenue. And this is another tool to cover up for their mistakes. It's really important to understand that there's no practical protection from a taking for a private use at this point. So the Supreme Court in Kelo may have said that, you know what, you can't take property from A and give it to B to benefit to B. But the problem is, if I'm a city and I've decided I'm going to take property and I really want to help my friend out, and my friend's going to build a shopping mall, how can you tell whether or not I'm benefiting my friend or if I'm actually helping the public generally by increasing tax revenue? It's almost impossible to figure out what the benefit is and what the use is. They're mutually reinforcing, as Justice O'Connor said in her dissent. Also, we talk a lot about cronyism here at Heritage Foundation, and I can't think of a worse example of cronyism than in this situation. I mean, we're not talking about subsidies to some developer. We're talking about seizing somebody's home to help some particular crony. And what's worse is that the developer, instead of actually paying the true cost of the property, is not going to do that because they can use the government as his or her agent to do the job for him and bring the costs down. Okay, so should Congress take action? And the answer is yes. And Dana, I think, covered a lot of the reasons why, actually. Look, if the Supreme Court decided to gut the First Amendment, I don't think we would feel very confident that the way to protect a federal constitutional right is through state law. mean, freedom of religion and speech, okay, it's protected because, New Hampshire has a state statute. I don't think that's adequate protection for a federal constitutional right. Furthermore, most of these reforms are state statutes, and state statutes can be changed fairly easily. It's not like a constitutional amendment, which is usually more difficult to change in states. So they can change at the whim of any new legislature. Congress did pass something called the Bond Amendment to the 2006 Transportation HUD spending bill. And it was a very limited type of reform that was limited to 2006. It was a way to address eminent domain reform connected to that spending bill. It wasn't necessarily that effective, and also just doesn't exist anymore, doesn't apply anymore. So what kind of action should Congress take? Look, at a minimum, we need to have some type of language that prohibits economic development takings and closely related takings, which I'll discuss, which are blight. Critics of any type of reform are going to complain about something being over-inclusive or maybe even under-inclusive. But if I have a default position, it's going to be to make sure that any language is over-inclusive, because I would rather err on the side of protecting individual rights than err on the side of protecting governmental power. When the government takes, if we simply developed a prohibition that government should not take property for economic development, that might sound good on its face. The problem is that by using that kind of language for economic development, we're looking at the subjective intent of why the government is trying to seize the private property. So what a city will do is they'll just identify a pretext of a public use that they could use. And a court is not going to try to figure out whether or not the taking is really for economic development, and that's the real reason, or if it's for this secondary kind of this public use that the government asserts. So what you have to do with any type of language, any type of protection, is you have to have burden of proof language in it to make sure that the city has to prove that they're taking the property for economic development, and they wouldn't have taken the property, that they would have taken the property regardless of whether or not there was an economic development benefit. And then 2 state constitutional amendments, Michigan and Nevada, actually have burden of proof language comparable to this type of language. Dana mentioned blight laws. One of the ways that the government seizes property for economic development is not, they don't usually come out and just say, you know what, we're going to take property because we want to build a shopping mall. That's not what happens. What they usually will do is they'll take property using a urban redevelopment law that the state has, claiming that property is blighted. The problem is that, one, the definition of blight is so broad that it can mean almost anything. And it certainly does not mean a property that's dilapidated, really falling down and unsafe. Oftentimes, it's actually property that could be perfectly fine. In some states, property, in fact, this is applied in the Berman case, property can be in pristine condition, but if it's in a blighted area, the city can still seize the property. So that needs to be addressed. So in any federal statute, any reform, should make sure that property, if it's going to be seized based on blight, the property itself must be blighted, so it's not necessarily in a blighted area, but the property itself is blighted, and that the definition doesn't allow for property that just happens to be old and hurts economic growth to be a reason for it to be called blighted. It needs to pose a very concrete harm to health and safety for it to be seized. So that's really critical. While any federal legislation, we think along the lines of state and local governments, it should also cover the federal government, even though they don't necessarily get involved too much with these, a lot of this eminent domain abuse that we're talking about. But on the state and local government, how is it that you can kind of enforce any type of prohibition on them? And the way to do that would be to use funds, federal funds. Recommendation would be to at least use federal economic development funds like community development block grants. That would be one approach, and that's at a minimum. There should also be a private right of action so that individuals, property owners themselves, can actually go to court and challenge any type of taking. And if they do in fact win their case, attorney's fees and related costs would be covered as well. Look, eminent domain and eminent domain reform is actually one of those issues that has bipartisan support. And there was bipartisan opposition to the Kelo case right after it came out, and it's been fairly consistent since. Last year, the House passed legislation called the Private Property Rights Protection Act, 2014, by a 353 to 65 vote. That's pretty overwhelming. The legislation does prohibit economic development takings and did have a private cause of action, has burden of proof language, and I don't think, after I read it, I don't think it properly addresses blight, but it's still a fairly strong piece of legislation, and it does withhold federal economic development funds. I mean, this is actually one of those issues where Congress can get something accomplished. And before rushing into it, if they're not going to properly address blight, then maybe they should hold off. I don't think they're going to get many bites of this apple. It's been 10 years, they still haven't passed anything. So I think with the 10-year anniversary, hopefully it'll get their attention, and hopefully the House and the Senate, it's really the Senate that's been the problem, will pass actual real meaningful reform when it comes to eminent domain. Look, the American dream of owning home shouldn't be threatened by this nightmare of eminent domain abuse that we've seen and we continue to see, not just with the 2005 case in Kelo, but in New York and Colorado and numerous other states. And there's no reason why we shouldn't be able to put this to an end. Thank you.
Thanks, Darren. So before we turn it over to questions, I just want to reserve the right to ask a question of my own for the panel, and then we'll turn it over to you all. And please, when you there'll be mics going around, please state your name and affiliation when you get the mic. And I'll obviously recognize you. So I have two questions real quickly. So perhaps one of the most controversial pieces of legislation and something that conservatives really support has been the Keystone XL pipeline. It's been going on for 5 or 6 years now. There were huge eminent domain takings in that case. So how can conservatives kind of square the circle? Huge eminent domain takings, but also something that they really support. And then my second question is for you, Dana. You mentioned Colorado and New York. How has Connecticut changed its laws since over the past 10 years?
Well, as to Connecticut changing its law, not much. We graded all the states on their legal reforms. Connecticut got a D. All it said was that you could not condemn property primarily for increase in taxes. That was it. They didn't do anything else. You can still condemn property for economic development in Connecticut. You can still take for private use. All you have to do is say, we would both like to increase our taxes and also like something else. And it is not presented any barrier whatsoever. Connecticut does continue to use eminent domain for all kinds of private projects. So Connecticut is one of the worst states still in the country. And that would be one of the states that certainly needs to change. It's actually kind of shocking that they did not do anything, but it was a state-sponsored project. And the governor liked it, even though it, of course, turned into a complete disaster, both financially and as a matter of public relations, and they could not bring themselves to fix it.
Darren, do you want to address the Kelo or the Keystone?
Okay, I should just follow up with that a second. I just want to reiterate the point that courts defer to cities on this. They're not going to figure out whether or not something's a public use. And that's what makes it problematic. Is that so if you have language that says primarily for something like tax, whatever, that's never going to happen. So, and then as long as they come up with some decent, even not even a decent reason, that'll be good enough. Look, I think there should be exceptions. First of all, never happy when the government is seizing property for eminent domain. And every state will be different along that pipeline. And there, though, should be an exception for, and has takings for utilities and common carriers. And I think that that's where we might draw a distinction here, because I think that you would think of the pipeline as a common carrier most likely. Paul, you might be able to have thoughts on that.
Professor Richard Epstein, formerly of University of Chicago and now of NYU, believes that those sorts of circumstances would be permissible. Think of also public goods. Anytime you had something like that, he would say that that would be a sufficient type of public use in order to be satisfy the clause. But the idea of having a regulated utility or something like that would be a way of trying to deal with this sort of problem in the modern context. That would be consistent with the spirit of the clause and what it requires.
Let me add one thing about the pipeline. I think likely, even under the actual original meaning of the federal constitution, something that is a public utility where the use is going to be something that is available to the general public would probably pass constitutional muster, but I actually disagree with Richard on this point. I don't think they should be using eminent domain for a private party. I think they should find a way to build it without, and I think they could. Now, that's not within the realm of constitutional possibility, and indeed the state statutes that got passed all allow for condemnations for public utilities, so I'm not saying that I think that this is really where the law can go or will go, but I also think that no one gives the slightest thought now to trying to do a project without eminent domain, and they could, even for something like a pipeline.
Great, thanks. Turn it over to y'all. Questions? Sure, right here. And please identify yourself and your affiliation.
Carl Golovin, endofthefed.info. Actually, I'll bring something from a slightly different angle into this, prompted by a Washington Post story, or our op-ed piece on Sunday, titled Andrew Jackson, Should He Be Removed from the $20 Bill? Andrew Jackson's farewell address in 1837, when he explained his reasons for ending the second bank of the U.S., it all points towards the skewing of the perceived value of everything since we've gone to a purely credit and paper system of money, without which the corporations wouldn't have the power, and we wouldn't be looking to the corporations for the jobs that help justify the taking of private property for, well, turning over the corporations. And in terms of activism, at the state and local level, some have tried applying Article 1, Section 10, no state shall make anything but gold and silver coin a tender in payment of debt. And at the state and local level, getting constitutionally sworn officials to be bound by that, to try to bring us back to an honest unit of account. It would be interesting if if their property was being eminently domained, if they were to make that argument, well, like compensation in gold and silver coin, it could help change the perception of what the real value of things is and bring it back to an honest unit of account.
That might go in the category of not within the realm of legally possible that I was just mentioning before. Actually, there was maybe 2 years ago, there was some state that proposed doing that. It was a bill that failed. But activism tends not to work well for something that abstract. Saving a particular property, yes, but anything that involves talking about the units of currency, probably no. That's at least been our experience in dealing with activism.
Eric Alston with the Charles Koch Institute, and you mentioned sort of no one would think about undertaking these kinds of properties or these kinds of projects without using eminent domain anymore. I was wondering, given that you said you have a list of how badly some of these have performed and many of them have failed, do you think it's actually inducing sort of economic actors to undertake more risky projects than they otherwise would, in that it's kind of like not only is it just a cost subsidy, but it might actually be a risk subsidy? Because it looks like the City of New London ended up holding that property. Pfizer didn't. So in some sense, risks that wouldn't be undertaken in a market scenario are willingly undertaken because the government's kind of brought in as a risk subsidizer. So I'd welcome anyone's thoughts on that.
Well, that's absolutely true. And so Pfizer was never going to own the property. It was that Pfizer was going to be in a nearby area, and this development was supposed to complement the Pfizer facility. But even so, absolutely, that happens all the time. The government puts in some huge subsidy for bringing a building there, doing this, and they agree to get them the property for less than they would normally have to pay for it. And sure, developers will try that. If it works, great. If it doesn't, well, that's not their problem. They'll move out. And yes, that does happen frequently because they're under no obligation. You couldn't even put them under any obligation. It's that the city hopes that bringing something or another will transform their city, but if it doesn't, there's nothing to be done about it.
I think a similar problem comes up when cities, for example, are trying to decide whether to underwrite the construction of sports arenas. What you have is the situation there where the team can extract whatever benefits it wants from the city, and then at the same time usually reserve the right to move outside the city. And so you wind up passing all the risk on to the consumers. The government corporation not really being the same position as a private corporation because they can pass the risk on to the consumer through the taxing power. Private corporations can't. And so the problem you're talking about can come up in that sort of circumstance, and I think it does come up whenever someone is trying to persuade the city to build them a new baseball, football, or soccer stadium.
Let me
that's-
just,
Go ahead,
on
Darren.
top of that, look, the state dollars were involved as well, right? And the city of New London needed to act by a certain period of time in order to use the money. Now, so different levels of government are kind of encouraging in some ways the use of eminent domain. And then when we see like with transit projects, the federal government itself tends to do that because if you can start to gobble up land and create density around rail projects, for example, or rail stations, you may have a better chance of getting the federal funding, transportation dollars. So the federal government needs to be aware of the fact, may very well be, that they're in fact encouraging the use of eminent domain. And one problem I didn't mention, but is this concept of transit-oriented development, where a city or transit authority, whatever it might be, will argue that it can take land maybe up to half-mile away from a potential rail station, develop that area, and say, well, the reason is not for economic development, it's really for transportation. You can kind of see how this mixed motive approach can kind of work for them. You can see how it's being abused. That's something that I hope the Congress takes into account as well. Furthermore, I would also say when you're constantly seizing property for a particular developer to help them, what impact does it have on a potential developer who might actually want to buy a property in a underdeveloped area? What's the point of buying property in that area if you know that in a year or two property might be seized or the property might be seized for somebody else? So it kind of discourages innovation, investment by developers.
That's actually a huge problem in areas where blight designations have been removed. They've seen an explosion of private development because you're finally safe to do that. So that is a big consequence of both having eminent domain for private development and then having these designations that say this whole area is up for grabs whenever we feel like it. One other, in some places like New York, for example, the flip side of this is if it's not a government promoted project that they're subsidizing, that they're using eminent domain, they won't let anybody develop anything. So for people who just want to buy property and develop, huge obstacles are placed in their way. For people who do a project through the government, they'll remove the obstacles. They'll take away the zoning problems, they'll waive their crazy requirements, they'll actually make it possible to do a project that otherwise could not be done. And that too creates a very disturbing incentive, because people that want to do a regular market-driven, no rights violations kind of project have trouble doing so, and the only people who are able to then are the ones who are willing to take other people's property to do it.
I mean, public choice theory would explain why this happens. The type of scenario that Dana talks about is one where if the government eliminates the restrictions and allows the market to handle the problem, down the road, when the market does handle the problem, no one in the government can claim credit for it. By the time the government sees any benefit, their original action will have been too remote in time for them to at least believe that the public will give them credit for it. On the other hand, if they continue to exercise some involvement in the project, it gives the people who are managing the project, as well as the legislators who allowed the project to be managed by other government officials, the ability always to claim credit for whatever benefit comes on down the road, because it's their decisions at each individual stage down the road that allowed something to happen that they can then claim credit for.
And we're certainly witnessing some of this here in the DC area with the Purple Line in Maryland, and also the DC United Stadium in Southwest. There are eminent domain cases that could be pending for those two projects as well. Other questions?
Mark Slobodian with Our Generation. My remarks are directed at Dana. Proponents of the takings clause have used the argument that the means justifies the ends. Now with Kelo and some of the other instances and the ones you keep track of more and more, in terms of a messaging point of view, is that argument largely sort of discarded and people haven't been pushing that forth and arguing for eminent domain for these types of uses? Or have they continued to adopt that, and how do we fight against that?
Well, I think it's a combination of two things, that they do continue to say that the ends justify the means, right? But it's more like the problem justifies the means, is typically the argument they make. Like, something must be done. Look at this terrible situation. We have a lot of unemployment, or this neighborhood is old. Something must be done. And then they immediately skip to, and this is the thing to do. So it's some combination of something must be done and we're well-meaning people, which we hear a lot. Like, the government isn't trying to destroy people's lives for no reason. They're trying to do something useful, and oh, oops, it just didn't work out that way. So it's a combination of those two. Like, we're well-meaning people, something must be done, this is the thing we will do. And I think the responses to that have to be, there are a couple different things that have to be done. One is certainly to show that if something must be done, this is not the thing to do. And we do that by having reports and studies showing that so many of these projects are failures. Also by showing that there are ways to develop without eminent domain, which there certainly are. And then just simply by making the moral argument that just because you mean well doesn't mean that what you're doing is good. You could mean well and be doing something really stupid and bad. And that's kind of the only response you can give. In some of these instances, I actually do believe that the city officials do not mean well at all. But sometimes they're just idiots, right? They're not trying to do something horrible, but they're really, really stupid. And thinking that the thing that they are doing could even possibly cause any benefit and not, destroy the lives of the people whose property they're taking. So I don't really think that's the issue, and that is often the point that I make, is that it really doesn't matter whether they mean well or not. The question is whether you can destroy someone else's rights for a promise of a benefit that may or may not occur. It's their property, they have the right to it. Go do something else that does not require violating anybody's rights, but yet could make your city a better place?
I think in a lot of policy debates, one of the rules that people go by is you can't beat something with nothing. And unfortunately, that seems to apply here. Someone who wants to develop an area can show that it's perhaps run down and then show also what it'll look like after they've redeveloped it. The problem is the nothing that other people like Dana and like Darren have to deal with is the fact that doing so provides a disincentive to private parties to come in and do that. But a disincentive, by definition almost, is something that's going to keep people from doing something. So you're not going to see anything happen as the result, and the people who want to argue in favor of allowing the property to remain in its current state in order to provide an incentive are put in the position of having to confront a visual depiction of the betterment of a community with the depiction of essentially an incentive that doesn't have any physical embodiment. The result being that you wind up in the position where you can have nothing visual that you can present to people in order to persuade them that your policy is going to be a lot better than the ones where the government is intervening.
I think we have time for one more question.
Well, if there are no more questions, can I just
Sure.
make the comment that I want to give kudos to Dana and to the Institute for Justice, because only through the actions on the ground in individual cases of lawyers like Dana and her colleagues can people like the Kelos hope to fend off the government's predations in this regard. Litigation is extraordinarily expensive, and it takes an incredibly long time. Most people are unwilling to do it. Most people are incapable of paying for it. And what you have here, as I mentioned earlier, are people who oftentimes are the type of politically powerless individuals that the courts tend to pride themselves as being the champions for. In fact, in cases like this, they're not. As I mentioned before, they've essentially treated it the life, liberty, and sometimes property clause of the Constitution, and that it's not just a public use, it's a public benefit, a public interest, or a public hypothecation or hypothesis of some benefit. What you have, therefore, is a need for people like these sort of organizations and others at the grassroots level in order to try to protect people who are being victimized by this. Susette Kelo is a real person. Property may be an abstract concept. Corporations certainly are. But the people that own these properties, like Susette Kelo, are real people, and what is happening to them are real harms. And it's only through the work of people on the ground, like Dana, her colleagues, and you who get involved in these sorts of matters, can you prevent these people from suffering real harms.
I think that's a good way to end it. Let's give a round of applause for our panelists and also Institute of Justice.